Capital punishment continued into 1972 when the U.S. Supreme Court in Furman v. Georgia temporarily paused all executions in the country for 4 years. Many people, even legal professionals, claim that Furman v. Georgia abolished the death penalty. However, that is not what the court held. The court specifically held that imposing the death penalty in this specific case was unconstitutional for the reasons that they outlined. One of the dissenting opinions in this case makes this fact crystal clear. A dissent is a minority opinion of the judges who disagreed with the majority opinion. The dissent even notes that only 2 of the 9 justices were in favor of a complete ban of the death penalty. The 4 dissenting justices wrote, "At the outset, it is important to note that only 2 members of the court, Mr. Justice Brennan and Mr. Justice Marshall, have concluded that the 8th Amendment prohibits capital punishment for all crimes and under all circumstances." The court did not rule that the death penalty was unconstitutional. It ruled that the way that it was being imposed was unconstitutional in this case. Specifically, the court noted that there was no consistent standard for when the death penalty was and was not being applied. This arbitrary application led to racial and economic bias, especially against poor and minority defendants. Because of this, the court essentially placed a pause on all executions in the country for 4 years to give the states time to make their laws consistent. After the Furman decision, Georgia, Florida, Texas, North Carolina, and Louisiana amended their death penalty laws. Those sentenced to death appealed to the U.S. Supreme Court to ask it to once and for all rule that capital punishment was cruel and unusual punishment. The court refused to do so and expressly held that we now hold that the punishment of death does not violate the Constitution. The court has consistently upheld this position to this day and has said that this question is settled.